Okay, I assume that everybody can see my screen now. Sorry. Yeah. Here's the third part of my presentation. Let's now turn to a broader topic that often interacts with trademark law, which is unfair competition. We'll take a brief look at how unfair competition claims can arise alongside trademark issues in China, and when they may serve as an additional or alternative enforcement tool. Now let's take a look at the anti-unfair competition law, compare and why they often go hand in hand in brand protection. Trademark law often focus on protecting registered trademark. So unregistered trademark is it can technically not can technically cannot be protected by trademark law. So trademark law giving rise over core and logos. It is the primary tool for and counterfeit goods. In contrast, the border scope is particularly useful when you're up against look-alike packaging, misleading practice. Unfair competition law can extend protection to trade dress, unregistered signs, and even the overall look and feel of. There's a key condition, the element that as the sign, the packaging must have gained a certain level recognition. You can't claim unfair competition for like your packaging is it's relatively new to the market and have not influence or recognition from the market whatsoever. That's not going to work. You're going to have to prove that your product packaging or your unregistered mark has gained some traction in the market to be able to claim unfair competition from the other side. But both law can technically be enforced through courts levels. So we can use them independently or in combination depending on the real case scenario. For instance, trademark law can stop someone from using your registered logo, but if a competitor copies your packaging design, layout, or color scheme without touching your trademark, the unfair competition law may offer the better route. So in practice, these two laws complement each other, and using both strategic and flexible enforcement coverage, especially in complex infringement. We're going to be take a look at two examples. Those are two examples I came across recently. Enforcement may still succeed even when trademarks themselves. Example, the first case wasn't handled by our team firm. I read it online. In this case, the upper one is the original one. Mark by trademark standard. Some in the verbal element. So by trademark standard, they are not identical or highly similar. Yeah, although the trademark in this case were not identical or even highly similar by trademark standard, the court still filed a violation on the grounds of unfair competition because of the overall dressing of. There's a lot common elements in these two dressing of the products, and this really shows that factors between trademark itself, such as trade dress, can still support a successful claim. The second case is a case I personally handled just recently. Again, the trademark used by another party, by the Kimberly in this case, the other party being a company. You can see that the trademark is distinctively different from the one of my. But when we're looking at, belief it was still actionable. We've now issued a citing unfair competition, and we'll monitor response and consider next steps if needed. This example of looking at the full content, but and also to show how combined flexible and effective protection. Now to wrap up the comparison between unfair competition and trademark, we can say generally speaking, trademark law is seen as the stronger foundation for enforcement, particularly through administrative channels. This is because registered trademark, they all have gone through substantive examination. Authorities are more confident in taking swift action. On the other hand, if you file an administrative action based out of unfair competition, I would say that probably not 70 to 80% of the chances that the administrative authority won't have that much confidence in act against the alleged infringer, because they're also afraid of counter allegation that they have taken wrong actions against the conduct of the alleged infringer, and the alleged infringer from the administrative authority. So just trademark, it's a very strong foundation for enforcement. Right, it can be difficult with administrative route. And the unfair competition law is more often enforced through the case involving unregistered marks, just like I mentioned. So it's from comparing this to firstly, I recommend that you get your key trademark registered as soon as possible, and then use the unfair competition law to protect unregistered but well-known elements like product packaging. Other than that, you might also want to consider copyright or design patent registration for your packaging, because they are also eligible elements for these two types that will add legal weight to your case when it comes to enforcement. And finally, you can combine both trademark and unfair competition claims in one litigation. Chinese courts are really very receptive to dual claims, and often apply both laws together in just one case for comprehensive protection. So this is the third part of which is about the interaction between trademark law.
Thank you, Rick. Really interesting topic, actually, that we just talked about in this
Thank you very much.
third section.